Check, check. This is good. I get in trouble with a microphone. Okay, first order of business is approval of minutes. I guess approval of the agenda. Do I need a motion for that?
Oh, do we need to,
We need to amend it.
amend this to remove
Thank you.
item 18, section 505?
Okay. Do I have a motion for that? All in favor, signify by saying aye. Opposed, same sign? No? Okay, we removed that one. Approval of the minutes. Approval of September 8th, 2025 meetings. Do I have a motion? Any corrections? Got a second? All in favor, signify by saying aye. Opposed, same sign. Okay, approval of the minutes, December 4th, 2025. Do I have a motion to approve? Second. All in favor, signify by saying aye. All opposed, same sign. Thank you, folks. Before we get into the meeting, I just want to remind our board members to, when we get into some of the complicated things like they've been getting the last few months, I want to just ask everybody to be careful about the crosstalk and stuff like that. I think it'll be better when we're seated out here in a long ways, but just pay attention to that. The other thing is, from a standpoint of ex parte communications, and what I'm speaking specifically to is after meetings, for example, and I'm a guilty one. I walked out of last meeting and did talk to one of the applicants, and that's a no-no, and I realized it was a no-no, and I walked, I got away. So, be careful. We have to, it's, these things are very legal, and we need to be careful of what we say and when we say it and who we say it to, for sure. So appreciate that. The hearing today, the hearing is a quasi judicial evidentiary hearing. That means it is similar to a court hearing. State law sets specific procedures and rules concerning how this board must make its decision. These rules are different from other types of administrative and legislative land use decisions. The board's discretion is limited. The board must base its decisions upon competent, relevant, and substantial evidence in the record. It is a decision constrained by the standards in the ordinance and based on the facts presented. If you will be speaking as a witness, please focus on the facts and standards, not personal preference or opinion. This meeting is open to the public. Parties are withstanding have rights to participate fully. Parties are limited to the applicant, the local government, and individuals who can show they have standing and will suffer special damages. Special damage may include parking, stormwater runoff, crime problems, or property value impacts. Proximity alone is not enough to prove such. Other individuals may serve as witnesses when called by the board. General witness testimony is limited to facts, not opinions. Individuals providing expert opinion must be qualified as experts and provide the factual evidence upon which they base their expert opinion. In this hearing, we will first hear from town staff, and then the applicant and its witnesses, and then from opponents to the request. The applicant may choose to reserve time at the end for rebuttal. Parties may cross-examine a witness after the witness testifies when questions are called for. If you want the board to see written evidence such as reports, maps, or exhibits, the witness who is familiar with the evidence should ask that it be introduced during or at the end of his or her testimony. Attorneys who speak should not give factual testimony but may summarize their client's case. With guidance from the board, I will correct you if you do not follow the proper procedures, and I will rule on all objections. Before you begin your testimony, please clearly identify yourself and your address for the record. There are no time limits on how long you may speak, but please be considerate of everyone's time and be concise with your comments. Also, I can and will stop a testimony that is irrelevant to the application, incompetent, unduly repetitive, of evidence already given, or a personal attack. Finally, by law, some kinds of evidence can only be given by an expert. For example, opinions about property values would need to be given by an appraiser, and opinions on stormwater would need to be given by a design professional. Okay. And each special use request will have to meet four standards. And then we will vote them on after each case. If anybody wants to sign up to speak, I think we have a sign-up sheet over on that table next to the gentleman with the state port pilot. If you're going to speak, please sign up. If not, our first case is Mr. Rich Bandera, representing Lucia and Terry Lindsay. The project is located on North Atlantic Street. What was that address? South Atlantic Street, 109 South Atlantic Street. So I will ask staff to start. Will you swear you in? You swear to tell the truth, so help, and nothing but the truth, so help you God?
I do.
Thank you, sir.
Well, thank you, Chair and members of the board. Tonight's presentation concerns a special use permit, SUP 26 Tax 02. It's a request by for a detached accessory dwelling units. The application is brought forth by the applicant, Mr. Rich Bandera, on behalf of the property owner, Mrs. Lucia Lindsay. The subject lot is zoned R10, which allows ADUs by way of special use permit and is approximately 9,300 square feet in area. This image is of the front of the house taken from South Atlantic Avenue. And as you can see, we posted our notification sign there too. Here we see the proposed building site of the prospective ADU. This image is taken from the side of the existing single-family residence and is of the backyard. Here is an aerial image of the subject parcel. You have an existing single-family residence, and directly behind that is another accessory structure, not dwelling, but a structure. And here's an aerial image showing that the subject lot and all the lots adjacent are zoned R10. Here's the applicant's site plan. As we can see, there is an existing accessory structure in the rear of the lot. The applicant had originally detailed that the structure would be removed, but since publishing the staff report, we have come to learn it will remain. Now, this structure is used for storage.
What structure is going to remain? I'm sorry.
The structure that's directly behind the single-family residence, sir.
That's my residence. I did want to bring up that I meant to say this earlier, but this improvement backs up directly to my house. So I just wanted to share that with everybody in here. I have not met the owners, so I've not had any communication. So, and I don't feel like anything would jeopardize my ability to make a decision.
There you go. What I'm discussing is the accessory structure that's directly behind the single-family residence. You can see it all the way to the right, rear of the property line. Thank you. This doesn't have a laser pointer, I don't believe. Yeah, it does. There we are. Thank you, sir.
So that it shows it's going to be demolished on the plan.
Yes. So originally, as I was saying, the applicant had listed it as being demoed. But after I've already published the staff report, we got word that no, in fact, the property owner is going to keep that structure. Now, the UDO allows for 2 accessory structures, and this would very well be one of the 2 that would be allowed there. It's used as storage, and I can give you a little bit more. It's about a little less than 100 square feet, about 22 by 24 feet in size. And yeah, so it's an existing structure. It's not really germane to the ADU side of the conversation.
But is that structure that's going to remain now subject to any setback rules?
Well, it's considered as legally non-conforming. It's really close to the property line. So it was constructed before R10 zoning came into play, and therefore they didn't have to abide by the the setback standards then. So,
Wendell, can I ask a question? The plan shows a smaller shed behind the larger shed that we're talking about. Is it to be demolished?
great question. So basically that smaller shed behind the larger shed is just a lean-to attached to the larger shed. So the problem that I got is my applicant, the application came forth with what I'm showing you here. After the fact, after I've published it, I got more clarity. It's just a lean-to. Originally, again, just to reiterate, this was listed as to be demoed, but since publishing the staff report, the property owner has decided that they're going to save it. And Mr. Bendera can probably speak more on that as to why, if so inclined.
Yeah, that was just my question because the original documents showed it being demolished.
Yes, sir. Yeah.
So it's kind of,
Yeah, and trust me, it was a conversation we had for an afternoon. It was a consuming conversation that we had for an afternoon. But by then, the report had already been sent out to you
I'm good.
guys.
I'm good.
All right, where was I? Here we have the applicant's site plan. As we can see, there's an existing structure in the rear of the lot. The applicant had originally detailed that the structure would be removed, but since publishing the report, we have come to learn it will remain. The proposed ADU will be the upper level of a detached garage that measures about 22 by 24 feet, totaling 528 square feet. The structure will meet the minimum side and rear setbacks of 5 feet. As the structure is less than 800 square foot threshold, stormwater mitigation is not triggered. Sorry. That might help if you see the site plan. Let me read that point over since the slide was lagging. The proposed ADU will be the upper level of a detached garage that measures 22 by 24 feet, totaling 528 square feet. The structure will meet the minimum side and rear setbacks of 5 feet. As the structure is less than the 800 square foot threshold, stormwater mitigation is not triggered. And again, the laser doesn't really show on white, I guess. Well, the darker blue right there is the existing structure that I mentioned, and up top of the image, that lighter blue is the proposed new accessory structure. The image on the left here is of the what will be the ground floor of the structure. Basically, it's going to be a garage for storage and parking purposes, whereas the image on the right will be the secondary floor detailing the ADU. And just for orientation purposes, the ladder well or the staircase is southwesternly faced. So if I go back here, I'm going to walk over to it.
So it's the side next to the house?
Correct. So here we have our ADU, our accessory structure to remain. Here will be the ladder, the staircase. And then I didn't make mention of it here. This will be 57 stone. Before questions about the previous ground cover goes through, this is all going to be 57 stone. Therefore, that doesn't count to the total of the previous ground cover. Garage doors will be facing right here, sir. Yeah, maybe a little over here. Can everyone hear me? Can I talk over here?
No, they can't hear you online here.
Okay. Thank you for bearing with me. So, image on the left is the ground floor of the garage. Again, it's 528 square feet. Here we have our ladder well. That would be again facing southwest property. Image on the right is our ADU. Again, 528 square feet. We have full bath, ladder well, refrigerator, sink area, and then this would be the living space. Here we have our elevation pictures. Again, the garage doors will be facing oriented on this side of the property. And the height of the structure will be about 25 feet. 25.
How does that compare to the height of the house?
That house is higher. Here we have 3.1, I use this just to illustrate again that this is a permitted. However, it does need to form board of adjustment or special use permits. And that other S stipulates that it needs to meet specific use standards. Speaking of which, here are our 8 specific use standards. I'll just read them out for you and I'll answer the questions. And then stop me if you guys have questions before I move on, please. Number 1, an ADU may be within, attached or separate from the principal residential structure. This is going to be detached. 2, the principal use of the lot shall be detached, single family dwelling, those are North Carolina code. The principal use will be a single family, the principal use of the lot is a single family dwelling unit still. And of course, it will be, those are North Carolina code. Number 3, no more than 1 ADU shall be permitted on a single deeded lot in conjunction with the principal residential structure. There are no other accessory dwelling units. Again, there is that one remaining accessory structure, but it's not for dwelling. 4, the ADU shall be owned by the same person as the principal residential structure, and that is going to be the case. 5, the ADU shall not be served by a driveway separate from that serving the principal residential structure. And that is not going to be an issue. It's going to be the primary residence served by a driveway coming from South Atlantic Avenue. And as I showed in that illustration, the 7 is going to carry it all the way up to the ADU. 6, there shall be a separate parking space for the ADU. That parking space will be available on the proposed driveway. 7, the ADU shall not exceed 800 square feet. They are at 528 square feet, which allows them to have the increased setback, decreased setback, 5 feet from the rear and 5 feet from the sides. And then finally, number 8, detached garages on the second floor accessory residential dwelling may not exceed a ground level building footprint area of 530 square feet. Shall be constructed behind the front building line, except as allowed for riverfront lots. And the response to that is that the ADU is detached and less than 530 square.
Can you please go back to the site plan and
Yes, sir.
there? Walk me through the parking again, please.
So again, 57 gravel. Here we have South Atlantic Avenue, single family residence. The property owner will come through off of South Atlantic, drive up, and this would be plenty of parking for their single family residence. And they can pull into the garage if they wish, or park outside of it.
Is there a swing room requirement for that driveway?
Okay, so. But the driveway is measuring 24 feet wide by 27 feet, 6 inches. That's going to be pretty, that's going to be sizable enough to at least do a 3-point turn.
Thank you.
Wendell,
Yes, sir.
if you wouldn't mind, please. Guess we have to go all the way back to the survey. Show me the existing driveway.
So there is no existing driveway. They have on-street parking right here off of South Atlantic.
No existing driveway. So we're adding a driveway.
Yes, yes, sir.
Which side of the house is it on?
It'll be on the, this side right here. So basically it'll be on the north western side of the house.
Plan north. So there's no existing driveway and we're adding a driveway.
Right.
And what's that condition? Sorry. I'm used to the old house. Oh, that,
We'll be back soon.
okay. All right, so there's no existing driveway. And we're adding a driveway.
Yes, sir. No existing driveway, adding a driveway with 57 stone.
Okay, so isn't there a condition, you said, one of your 8 conditions that focuses on driveways? I just want to make sure I understand the fact that there is no existing driveway, we're adding a driveway, and that doesn't conflict with
Basically says, yeah.
the ADU shall not be served by a driveway separate from that serving the principal residence structure. So
So what they're saying.
unwind that for me.
ADU shall not be served by driveway separate from that serving principal resident structure. I'll go back to the, image. So this driveway will be serving the principal resident structure. They can park right here. It's not like they have a secondary driveway serving the principal. So this driveway will be something that is, going to go in that they don't have already as, stated. And it will serve the principal residential structure and the ADU. So that stipulation is making sure that, the ADU doesn't have its own by itself driveway. If I could just illustrate a little more, imagine that this lot line carried all the way through South Atlantic. That, and this driveway consistent, what that, number, what that bulletin point is saying, you can't create another driveway for the purposes of just serving this along here to feed into the ADU. But the applicant has proposed, and rightfully so, it's just one driveway serving both the ADU and the single family residence.
I think what's to note is when you're down in this area where you have no assigned park.
For these houses down in this area, there is no assigned, we have no parking.
Right.
And so what conceivably, somebody could park right out in front of their house and block their driveway. So to me, this is a great solution. I wish I had the opportunity to do it, but I don't have the room. But yeah, I understand what they're trying to do and why they're doing it. So it makes perfect sense,
And again, because they're using 57 stone, it doesn't, trigger that 800 square foot or greater.
Right.
Will you elaborate on 57 stone for anyone who doesn't know what it is, please?
Yes, sir. So 57 stone is a coarse, gravel. It's, you can get at any stone masonry pit. It's used for general construction, generally as, an impervious material that could, be used for like driveways. And the theory is that because it's not a consistent solid material, rain can, percolate through the stone and reach the water table. So that's how we determine that it is, impervious.
Thank you. This property's not in the flood zone, is it?
No, negative, sir.
How many other residents have driveways off of South Atlantic?
I couldn't speak to that. This is part of our research to look at. It's not unique. No, it's not unique, to some corporates. That would driveway feeding into the back of that property, especially for those downtown, residences where like the chair, mentioned, you have a lot of on-street parking, but it's not guaranteed. There are some residences that do have driveways that feed to that.
I think there's, 3, if you count this one. Margaret has one. Dr. Conrad, Miss Conrad has driveway. On the other side.
Well, this concludes my presentation. I can answer any questions regarding it or the staff reports. Mr. Van Buren is here also, who's the applicant. He can answer more questions regarding the design, if you have those types of questions.
Sorry. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Do.
Thank you.
I apologize for not having that survey or the existing building to remain. And Wendell and I have talked quite a bit about that as far as keeping that. There is although it doesn't fall under the stormwater ordinance, there is a net increase in impervious because of the new building by 607 square feet. The way I understand that, it's triggered when you go 800 square feet or above. So we fall just slightly below that. As far as the access, I think your questions were pretty spot on, I guess, is that the driveway is there for both the accessory dwelling and the residence. There's 2 bays, and on the historic area, parking is allowed for the dwellings for the primary part on the street. So the real requirement for parking is solely for the accessory dwelling. The building at 528 square feet is pretty straightforward as far as a 2-bay garage with a 24-foot turnaround area and an accessory dwelling that's not too different than what exists in the neighborhood, staying roughly around 25 feet in height, which is 5 feet below the maximum for those types of structures. That's really all I have right now. I should say that a permit's been filed for the garage, the building and its siting already, and this use change is we're kind of running dovetail with that permitting process. I can answer any other questions if you have.
Questions for Mr. Bandera? Questions? Thank you, sir. I guess we can go. Close the public hearing. Anybody want to speak in opposition, here to speak for or against? I didn't see the sign up sheet, so if not, I'm going to go ahead and close the public hearing and
Just-
discuss.
Just quick, just want to double check to make sure that because if the board chooses to approve the submittal, we're not in any way endorsing the existing violations of these setbacks. I know that you'd mentioned that existing structure is very old and it was in place before zoning criteria and bulk criteria were established for the city. But now that we're talking about today, and I just want to make sure that we're not sitting there going, oh yeah, and it's that 0 setback on that garage that you're now keeping. Yeah, you can have that. I want to be very clear on that.
Excellent question and point, sir. No, so this approval is for a brand new ADU detached garage, and it has no bearing on what is there on the lots. Now, I will say to that point, if Mr. Bandera were to come to me and say, hey, Wendell, we want to take this existing structure, build it up into an ADU, put an ADU up top, that'd be a no-go, because then you're increasing the legal nonconformity, which is making it a non-legal conformity. So to that point, no, you are not in any way encroaching on any existing legal nonconformity situation. This is all a brand new thing that is completely divorced of what else is there on the property.
Wendell, if that workshop or that building was to be demolished and they came back with the plan to build something else, would the setbacks be required then?
If the property owner demoed that building, the clock starts immediately upon the issuance of that demo permit. They have 180 days to build into that footprint per the state statute, 180 days. At 181 days, tough luck. You now have to come into complete compliance with that zoning requirements. So those setbacks, those height standards, design standards, et cetera. But 180 days, they can be in that exact same footprint and no harm, no foul.
Thanks.
Any other questions? All right, I'm going to close the public hearing. Any discussion? All right, well, I guess we'll, take a vote. I'll go pretty quick here. Just for people to know, the chair does not vote unless there's a tie, in case you see me not voting, so. All right. Seeing there's no more discussion or questions, do I have a motion, for number one, please?
I'll make a motion, the use will not materially endanger the public health, safety, or general welfare if located where proposed and developed according to the plan as submitted and approved, with finding of facts, being increased public safety due to creation of off-street parking. And is that good enough finding of anybody? If anybody else has any finding of facts they want to throw in, please do.
Requirements of the UDO. That's part of it. Yeah. Finding of facts. We'll add
I'll
that.
second it. Pete.
We have a second. All in favor, signify by saying aye.
Aye.
Same sign for no. Motion carries. Motion number two. I have a motion.
Use your microphone.
I'm sorry.
I move that the use meets all required conditions and specifications, with finding of fact that there's no outstanding points in the UDO that are not fulfilled.
Second. We have a second. All in favor signify by saying aye. Opposed, same sign. We got one opposed? Okay. All right, motion carries. We have motion number three.
I'll make a motion, on number three, the use will not adversely affect the use or any physical attribute of adjoining or abutting property, or that the use is a public necessity. The finding of fact being that, the new accessory structure has 5-foot setbacks and the height is below the maximum limit permitted by the UDO.
Do I have a second? A second. All in favor signify by saying aye. All opposed, like sign. Okay, thank you. Motion 4.
I'll give it a whirl. I move that the location and character of the use, if developed according to the plan as submitted and approved, will be in harmony with the area in which is to be located and in general conformity with the City of Southport comprehensive plan, with finding of fact being that it meets all UDO requirements relative to the footprint. And I don't know if there's any others that anybody would like to tack on.
Do I have a second? Jason seconds. All in favor signify by saying aye. Opposed, same sign. Motion carries. All right, 5. Somebody want to make a motion?
Motion to approve it. I don't have any.
Based on the findings and facts that evidence presented, the Board of Adjustment said recommend, who said recommend approved? Rodney?
Yep.
Do we have a second?
Second. We got conditions now?
Yeah, we're next after that, or is it before? Is it before or after?
It's part of this, is with it.
Go ahead now. You want to add your commission?
Revise the plans to reflect no demolition.
What now?
You need to amend the plans to eliminate any reference to the buildings being demolished, because now they're going to stay.
Yes, sir, I can fix that post haste.
do we, yeah, I was just asking that. Do we need to, is it automatically added now or no, we still have to add the part about the rentals? Someone want to include that, please?
Move for a second condition I move for a second condition of our, that the accessory, use dwelling, excuse me, accessory unit cannot be, rented separately from the remainder of the property.
I got that. I got a second. Do we have a second? Had
Second it again.
Okay. All in favor of the motion signify by saying aye. Opposed, same sign. All right, we approved it. We will, Rich, as you know, we'll get a letter out to you within a couple of weeks with the results. And does anybody want any of that information? Talk about the survey or anybody, or everybody happy? I'm assuming staff's gonna take care of that. So, okay. All right. Thank you, folks. Give us a second. If we need, we'll break it. I don't. Okay. Our next case, well, let me see here. We have an appeal of an administrative decision, I believe. And I believe Miss Jennifer Carpenter will be representing the owners. Would you like to come up, please? No, hold on. I'll let her go first. I'm sorry. I messed that up. I got ahead of myself. Jason's supposed to hit me. I tried to do this one time.
Sir, will you swear me in, please?
You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
Thank you, ma'am.
thank you.
Thank you, Ms. Meehan.
Good afternoon, Chair and members of the Board of Adjustment. Our next case, different clicker I'm used to, is an appeal to an administrative determination decision that was made by our code enforcement officer, Harlan Piles. The subject violation is the use of an R10 residentially zoned parcel for commercial parking, which is unpermitted use in the R10 zoning district. The property owners were issued their violation on April 9th of 2025 under section 3.5, table 3.1 of the UDO, which is outlines the commercial parking lots. The remedies that were outlined in the letter of notification of violation was for the abatement was to cease use of the properties for parking. The subject properties are located on the corner of South Caswell Avenue and West Bay Street. And they are, as you can see, depicted on this map with the two dots, the two yellow properties. The yellow properties that are shown are zoned R10 residential. The reddish pinkish colors are business district. So those are the BD properties that are adjacent to it that are part of the Yacht Basin area. The violation was to table 3.1 that you have in your packet. And it shows that commercial parking lots are allowed on the office and institutional, central business district and business district with a special use permit and standards. And in the highway commercial zoning district, it is permitted with standards. And those standards are outlined in the UDO. The definition of a commercial parking lot is any premise that is used for storage of motor vehicles for the public or private business. The definitions of this parking lot, commercial parking lot, do confirm that the parking on the subject R10 parcels is in violation of the UDO. So just a little bit of history for this area. I have some photos. And I wanted to say that the property owners in this area have historically, in the residential area, have been closed for parking, and then the adjacent business districts, they had commercial parking that were related to the businesses that they had within that area. There were some special events that would take place, such as one example would be the Wooden Boat Show, where some of these lots would be opened up for use just for those special events. At the time, in the earlier years, that'd be late, probably in the 2016, 17, the Wooden Boat Show was a much smaller event than it is today. So it was just, being used by the Boy Scouts some to sell their hot dogs and to have some other exhibits on those areas. In the early 2020s, these lots began to be used more for commercial parking as the area and demand for parking became real. So as you can see, these two aerial photographs that I have provided here. The one on the left is June 2019. You can see that the properties adjacent, the business district ones, they have parking on site, and the properties that are residential in nature and zoned residential are the four that are in that L shape. The two that are subject properties are again on that corner of South Caswell Avenue and West Bay Street. You can see where it is grassed and there has not been any parking. Again, on the right, we have an aerial photograph from September 2021, again showing the same circumstances.
Mo, real quick,
Yes,
sorry.
that's fine.
Could you scroll up just a little? I just want to go back to that zoning map, just for a brief moment.
Yes, sir. Yes, sir.
That one.
Yes.
My version has, all right, you've got your two dots. I
Yes,
get that.
sir.
But the two lots above that,
Yes.
my exhibit shows them being zoned as POD. I just want to know what that is.
Yes, and I have a slide later to show that is the parking overlay district that was then adopted in the
Okay.
last year.
Thank you.
Yes.
I saw the difference. I just wanted to bring you back to that.
And just to follow up with that, so the parking overlay district is just an overlay. So any underlying zoning districts that exist, so the R10 zoning that exists on the properties above these two subject properties are still zoned R10, so residentially zoned, but have this overlay district on top of it that allows the parking on it. So I will go into that a little further, but that's the difference that you have on that one. You're welcome. Again, so these are some lots now. So April 2023, you can see that some of the parking has been allowed where you can see the grass is missing. There's some openings to these lots and also to the lots north of this area as well on the residential properties. And then on the right-hand side, you have the aerial photography that is from October 2025. This next photograph was taken in August of 2025 from the street, and this is looking onto the lower parcel, which is, this is taken from West Bay Street, looking towards South Caswell, and you can see the parking within those bollards behind the white car, showing where there is a full parking lot on the subject lots that we are speaking. So as we have mentioned that these are all residentially zoned properties, and in the early 2020s, the parking became more prevalent. The parking was needed, and city officials recognized the benefits of these. So there were several city initiatives that led to this overlay that we are speaking of here momentarily. So in 2021, there was a Yacht Basin Committee that was formed. And one of the recommendations that this committee recommended was that there be a parking overlay to allow and legally allow this parking to exist on these residentially zoned properties. That did not necessarily come to fruition. There were some other studies that came about, and there were some changes in staffing at the time. So in 2022, there was a yacht basin mobility study that took place that also studied the patterns of the parking and pedestrian use of the area in the yacht basin. And then further in 2023, there was a downtown parking study that took place, again, to study where people were parking, what types of parking opportunities existed, and where else that they may be able to increase parking. Again, the parking overlay was one of the options that was brought forward to allow parking within these areas that are residential again, but the overlay would provide them to allow legally established commercial parking on these properties. Again, this is a destination. So after we went through the 2023 downtown parking study and the comprehensive plan was adopted, then in November 2024, the planning board was presented this language for the overlay by staff, and they put together a committee, and they invited all of the property owners in the R10 districts on this section of South Caswell between Westmore and West Bay Street to be included in the conversations to see how we can accomplish this type of parking and what they wanted to, how we could work with these property owners to establish the legalized parking. The owners of these two subject properties were invited. Staff reached out and they received an email back. This email was dated on January 24th, 2025, where Mr. Cherico declined the invitation to the review committee meeting, stating that he and Mrs. Cherico were not interested in participating in the overlay district. So staff moved forward after that November meeting or January meeting, and then forwarded the map, which would be the hatched or the blue on your exhibits in your packet, that show the overlay for the two residential properties that were included as part of the overlay district, and then were eventually adopted by the Board of Aldermen on February 13th of 2025. And at this time, I would like to add that I need to include Exhibit 3 was inadvertently left out of your packet, so I want to go ahead and submit those to you at this time.
No, is it still the overlay? Is it still existing as it started? So no one's pulled out or?
Yes.
Prior to the adoption, maybe an obvious answer, prior to the adoption of the overlay,
Yes.
was it legal to park anywhere down there?
It only in the properties that were zoned business district. Yes.
That didn't change the order.
That did not, yes. So I just wanted to, the Exhibit 3 that I just passed out was the language and the map that was adopted by the Board of Aldermen, just so that you had that in front of you. So that was adopted. Once that adoption was became effective, staff then went ahead with a notice of violation again on April 9th, that the violation of section 3.5, as you can see, and they needed to cease the use of the property for public parking, commercial parking. Other abatement options that have been offered are to, one, request to be included in the overlay. Staff would be willing to move that forward. We did not require the two existing properties in the overlay to request or come in for a zoning change. We did it for them with no application fee, so we would be willing to do that for these property owners as well. Or the other option would be to come in and apply for a rezoning to a business district and then apply for a special use permit that would establish a commercial parking lot. So those are their options for abatement that we have provided. So in conclusions, the applicants allowing the public parking on the property does constitute a violation of the UDO, and staff requests that the Board of Adjustment reaffirm the initial notice of violation, ordering the applicants to cease commercial parking on their subject parcels. The parcel numbers are 237 LF001 and 237 LF002. That concludes my presentation. If you have any questions, or if we wanted to,
I have a question, Mo.
yes.
So is it the city's position they want that to be used as parking?
Yes, we have no issues with it being parking. We just want it to be legally established. Yes.
And why did we not, the last drawing you had up there? The properties that are hashed, are they still R10?
They are still R10. So the way a zoning overlay works is any underlying zoning that exists previously, so this R10 still exists. So at any point, if someone wanted to, one of the property owners that has the overlay district established on their property wanted to come and develop their property as an R10 property, for any uses that were allowed under that R10 would be allowed to develop the property as an R10 property.
Okay, but this overlay came when?
The overlay was adopted in January of 2025.
Okay.
Or February, I'm sorry, February 13th, 2025
And
was adopted.
so the ones that are in the hash prior to this amendment was a parking area.
There was one parcel that was being used as parking. And the other one would like to have the potential to use it for parking if, at some point, if they choose. Again, this is with this overlay
No, the
existing.
parking lot for Fishy Fishy,
Yes, sir.
was that R10?
No, sir. That property is zoned business district, and so you'll see that on the corner, down at the end of Westmore and Yacht Basin Drive, the large red square below the hatch, to the left of
Okay.
the hatch, that's the Fishy Fishy parking lot. So
Okay.
it is zoned business district and is allowed to have the commercial parking on site.
All right, thank you.
I have a question. When they received the violation, was there any sign that says parking or bumpers that says these are parking spots?
There were no official parking signs or bumpers, but the lot was open and it was being used for parking.
Is this the area where the guy came in from Frying Pan and had to have it done this April or whatever?
Yes, so the property above these two on the corner of Westmore and South Caswell that is hatched, there are standards attached to the overlay that requires that you put in wooden borders around your property and include 57 stone so that there's a safe driving on the surface.
Folks, we're not used to being with microphones, so I appreciate this is a first for us. So if the property is just left, right as is now, what's to prohibit people from parking on that property and going ahead of in the future?
Yeah, well, and previously the property did have bollards up with chains that kept people from parking. So in the earlier aerial photography that I showed, they did have bollards up with chains. And at one point there was a sign that says no private property, no parking. So we would ask that they would close the lot so that parking could not exist on those properties.
You could ask, but
I mean, I can't make them.
you
correct.
can't put
That's
you
correct.
can't make them put a gate up or anything like that.
Correct.
Okay.
This seems very odd, like I'm just inefficient. We want parking there, but we're telling them they can't have parking there. I mean, just seems inefficient and we have to go through this whole process to get what you want. what they're doing.
There's a legal basis for parking lots, and this is in violation of it.
I
If we
mean,
start throwing out,
if they were monetizing it, I could see that being an issue. If they're saying park
I mean-
here, there's clearly a parking lot, but it's not, it's an empty lot.
we can either amend the zoning or we can apply the rules, but we can't just willy-nilly do anything, or we open the door to all kinds of violations that we can't control that actually would have a substantive impact.
And can I,
There's special circumstances, like for instance, the first appeal, first appeal that we decided to deny, I guess you would say, or to accept the appeal, you know, it's circumstantial. And I believe this is extraordinarily circumstantial. I mean, R10 is the same thing as the neighborhoods back here. So, I mean, this is in the most commercial area we have in Southport.
Yeah, I don't get your point.
Well, this isn't this is an appeal decision. It's similar to what we've gone through already in terms of,
Yeah,
so what I'm saying is we're not amending zoning here. Are we?
I think we need to hear the,
Not affirming a
Correct.
staff administrative decision.
in what way is I think we need to hear the rest of the presentations from both sides on this.
I agree with that as well, but I just feel like just walked around in circles there.
let me say one thing that it's not, I don't think it's really correct to say the city wants to have parking there. That's not what started this. It's not a desire of the city. It's simply the way of the city saying, if you want to use this property for parking, here is a legal way that you can do it.
I think the city
That's-
hired a study to see where parking can be, and they identified these spots as parking. Is that accurate? Or am I-
Yeah, but it's because the businesses want more parking. I mean, you got it. They
I mean,
They
if
actually,
the public
the
needs
full
parking-
history is that the property owners came to ask for that R10 to be rezoned to business so they could park on it. That's really how this whole thing got started. So, I mean, it's really the city's been trying to respond to the businesses.
That is all I have at this moment. Thank you.
Any more questions, Mo? You're going to come back.
We're not even at the point of calling direct testimony. Not even at the hearing yet.
She was just getting ready. She finished her report. There's no more questions. On the cover.
Yeah. I was just gonna briefly go up there and say about 3 sentences and then sit down. That's gonna be my opening, but I'm also gonna give Ms. Carpenter an opportunity to go.
Oh, yeah.
And at this point, I also want to object to any additional information that was provided in that presentation that was not the agenda content that was presented to us. And so any extra pictures, testimony, comments, or anything else that was introduced, evidence that
Well, I'll just say that we did provide all the record and materials prior to. I'm still going to go and ask to enter in the PowerPoint into the record as well as the staff report, all of the city's exhibits, and as well as the exhibit 3 that was just handed up by Ms. Meehan. I don't want to, we're already kind of like in the meat of this already, so I'm not going to go and waste too much time, but I will go and give Ms. Carpenter an opportunity to do an opening if she wishes. Or I'll just proceed with the city's direct examination. And sorry, Brady Herman, city attorney, here on behalf of the city staff's decision.
Well, Brady, just as a matter of efficiency, then why don't we start? Ms. Carpenter, do you have an objection to this? It seems like the order of operation ought to be that Brady go ahead and conduct direct examination if he wants to of Ms. Meehan, and then you can cross. Before we move in. Oh, of course. Sure. But his direct will obviously impact your cross-examination, so.
Yeah, all I was trying to do is sometimes we give opening statements like it's like a court hearing. And-
Okay.
and sometimes it's efficient, sometimes it's really not necessary. Here, mine was going to be short anyway, but I just wanted to give Ms. Carpenter an
Okay.
opportunity to do an opening if she wanted to, which is just a forecast of the
Sure,
evidence. It's us
sure.
not making,
Right.
giving evidence.
Gotcha.
So to that degree, I'll leave it up to Ms. Carpenter. If not, we'll begin with Ms. Meehan.
Would you like to do an opening, Ms. Carpenter?
Yes, I would like to do an opening if, Mr. Harmon, if he wants to go first. Gonna get feedback. I don't want to.
Which would you like to use?
This one's. Good evening. My name is Jennifer Carpenter. Again, I'm here on behalf of the property owners of lots 1 and 2 that bring us here today. That is actually Yacht Basin Holdings 2 LLC, which is owned and operated by Mr. and Mrs. Trico. We're not here today to talk about rezoning or the overlay district or changing zoning. We're here today specifically to talk about a notice of violation that was issued on April 9th, 2025. I'm going to try to keep my comments and my presentation limited to that specific purpose. Sometimes it can get a little bit sideways about what actually the purpose of the board is here today, but it's basically to decide whether or not, as the chair said, whether or not the staff determination was correct that my clients were in violation of the ordinance that deals with commercial parking lots. First and foremost, we'll take a look at this when we get into the evidentiary portion of it, but you have the notices of violation in your packets for the agenda. Those notices are insufficient under your ordinances and under state statute in that they say that they are a courtesy notice. They are not a final notice and they are not a final determination by the administrator. They also say there may be a violation of ordinance, not there is a violation of the ordinance. One of the things that your ordinance requires is that the owner's appellate rights are listed in the notice and you won't find that anywhere in those notices. So at the outset, I would ask that these notices of violation be dismissed before we even get into any of this administrative hearing or appeal. Just based on that alone, I don't believe that these are a final determination by the staff and they should be dismissed for not complying with your UDO, which requires those things to be put in the letter. If we need further evidence on that, I'll be happy to present it later. The second point that I'm going to make in my presentation is that the notices themselves, if you decide that those are a final determination, they're vague, okay? They're vague about what the violation is. They don't identify the conditions that cause the violation. And they're also vague about what the remedies are. The remedies that staff presented to you, which was to join the overlay district or apply for a rezoning, you won't find those anywhere in the notice of violation. Okay, those options were not given to my client, nor were any other options. It said you're operating a commercial parking lot, don't do that. And as you'll see from my presentation coming up, there's a case on point that just came out from the Supreme Court. I'll be happy to give you a copy of that. That says it's got to be very specific because you're taking away the property rights of an owner. And in order to do that, you have to be very specific in your zoning ordinances because we favor the free use of property. The final point that I'm going to make is that everything that you've seen in the staff presentation so far, we'll point this out once we get a couple of witnesses up here, is that you won't see a single photo from the day that the enforcement officer was supposedly at the property doing the investigation and observing the conditions that caused this alleged violation, okay? They're from 2019, 2023, not 2025. If you look at the picture from 2025, you won't see any cars parked on my client's property. So we'll go more into that as we get through this hearing. If again, you decide that these notices of violation are sufficient under your ordinances and state statute to give my clients notice of what exactly the violation was and how to correct it. Otherwise, I ask that you dismiss them at this time. And that is the conclusion of my opening.
I'd like to ask our attorney, right?
Oh,
Respond to that, or
Be Mr.
Brady?
Herman.
Brady?
Yeah, Mr. Herman would be giving a response to that.
Well, I'll just say this, that the notice of violations were part of the record. They're part of staff's decision. Whether or not those are legally sufficient is a question for you all to go and consider, and it doesn't pertain to excluding them from the evidence. It's part of the city's record in terms of what's being appealed today. And I'll just say this, that, you know, that letter was sent out 9.5 some months ago. If there's legal deficiencies with that letter, certainly those could have been raised between now and then we're hearing it for the first time. Doesn't really make a whole lot of sense to me, except it's a last ditch effort. So to the degree that you all just want to go ahead and exclude them and not even have a hearing, one, I don't think that's procedurally correct, and it's a complete waste of everybody's time. So I ask that we keep it as part of the record, and whether or not that has an influence on your decision, albeit I'll say that, again, the standard is you put yourself in the shoes of the zoning administrator. And I'll be happy to go and through our direct examinations, you know, go through what the notice and violations entail. So that's my response to that. I guess happy to answer any questions, and I'll leave it up to Ray on how, Ray and the chair, on how you all want to go and move forward in terms of ruling on that motion. Or
I'd have to ask advice from our attorney. Right.
My recommendation would be to go forward with the hearing and take in everything that's presented. You can consider arguments like what Ms. Carpenter raises, even with respect to not considering or accepting certain items as exhibits as part of your decision. It could be one or more basis for not upholding the notice of violation, for example. So I don't think that those reasons are bases not to continue the hearing after proper notice of the hearing itself. That's my recommendation.
Any questions here? Oh, Ray? Pardon?
Has a final notice of violation been issued?
Mo?
No, there was not a final notice of violation issued since this first notice was appealed.
Is that the proper procedure for the first notice to be subject to appeal?
Any staff decision can be appealed.
You outlined some options that you said were presented to the appellants. When were those presented and
Yes.
how?
Yes. I'm sorry.
When were those presented and how?
The first one of ceasing operation or using the property as commercial was again in the notice of violation. The other ones I spoke with our counsel that that was then sent to the other council that I was aware of. I mean, that was my understanding.
Was that transmitted, determined?
It was, but I don't want to get.
Well, I'm asking to get into this because I think we need to make a determination right now whether we need to hear the next hour and a half of information on this. If there's not been a determination of violation, we shouldn't even proceed.
right. Well, you're talking about the potential options to resolve besides just using the lots for parking. Is that what you're asking?
Just the procedural issue here, that's all we're here to decide is whether the standards have been applied correctly.
Well, that can certainly come out in our direct examination.
Okay.
But were you asking about the appellants getting notice of potential options besides you?
It seems very much like this is a process that's been caught midstream and hasn't reached any kind of resolution point on the part of either the city or the property owner. And so I'm wondering how we can be making a determination on whether there's been right action by the city and its findings when it doesn't seem to technically have any findings yet.
Without having the ordinance right here in front of me, I wish I would have gone and reviewed that letter before it went out, but I did not. So I'll leave it at that.
But it is a first notice that we're hearing as. being
From everything I understand, there doesn't need to be two notices of violation. Why it's styled courtesy notice violation or courtesy violation and first notice of violation, I can't speak to that. I didn't review the letter.
I would just say maybe one point on that, just to keep in mind is that, however it may be styled or presented, and again, I'm not here as an advocate for either party. I'm just trying to look at this objectively. It's not my role to decide. But thinking about it objectively, one point to consider is that however the titling of the letter or notice might be, there was an appeal from it, which would suggest that the applicant or the appellants themselves treated it as though it was an administrative action that imposed an adverse consequence or would impose an adverse consequence against them if they did not act in the way that they did, which was to challenge it. So something to keep in mind as far as whether they had sufficient notice of what they were being alleged to have done or not done. The other part I would say is that I just made a recommendation as to how you should proceed or if you should proceed. My recommendation is that you probably should. Not my decision to make, but it probably is something that the board should decide collectively on, because I'm only just giving advice as to whether you should proceed or not proceed in light of the procedural question that's been raised by the appellant. So you should.
Please.
Just two quick points to address things that were brought up by opposing counsel. Number one, this I think actually was brought up by staff. Every single decision can't be appealed. Under North Carolina statutes 160D, only final determinations can be appealed. The fact that we filed an appeal to preserve our rights doesn't have anything to do with how we treated that letter or whether or not it was actually a final determination by staff. That is a decision of law that gets to be made by you here today. And that's what I'm asking you to do. I'm asking you to look at your ordinance, and I have copies if you need it, where the ordinance specifically says what needs to be contained in a notice of violation. And the rights of the appellant to appeal is definitely one of them. And I also have a case that says you have to be very specific about what the violations are and what the remedies are. And even just from staff presenting what they've presented thus far without any evidence from witnesses at all, you've seen zero photos of anything that would constitute a violation on April 8th, which is the day that the violation was supposedly to occur.
Yes.
Go ahead, Mr. Herman.
Brady, please.
I mean, just because it appears we're hashing this out right now, and I don't know why opposing counsel just doesn't go up here and has the ordinance in front of her and starts reading it off. But in any event, it's UDO section 2.15, subsection 2. It says the final written notice and the initial written notice may be the final notice shall state what action the administrator intends to take if the violation is not corrected, and shall advise that the administrator's decision or order may be appealed to the Board of Adjustment. I don't dispute that the letter did not have that you have a right to go and appeal. But at the end of the day, they went and appealed the letter within the 30 days. It was timely. If that was an issue, it could have been brought up by opposing counsel at that time. Essentially, they have waived that sort of procedural defect to the degree that they did go and appeal. And we are having an appeal in front of you today. Again, it's 9.5 months after the fact. So if this really was depriving some sort of due process for them, it's been addressed. We're at the appeal hearing today and right now. I don't know how much more clear the notice of violation letter can go and state. It says your property is being used for commercial property, which is not permitted in the zoning district. And then it said, please stop using your property for commercial parking. That's verbatim according to what the UDO says, again, besides the notification of appeal rights.
Questions of Brady? Mr. Herman, sorry.
I would just say that, Mr. Herman's point about waiver of the arguments being made now is something to consider, because if you look at the letter, the email that was prepared has a as the appeal, which was dated May 9th. It's in the packet, page 123. It asserts a few bases for the appeal, and none of those include what have been raised right now. Arguably, what's being contested or what's being raised right now is reasons to essentially dismiss and not proceed have been forfeited. You could look at it that way. And just as a net effect, I mean, arguments that are forfeited just can no longer be pursued. So even if they did otherwise have merit, they wouldn't be bases on which the party could continue to pursue their position.
Absolutely not required to list every basis for appeal in the notice of appeal.
I'm simply saying that that is a valid point that Mr. Herman makes, that you had the opportunity to make the same arguments at that time, and it would have been apparent from the same notices that you received, which you're interpreting on their face at that time. So they are arguments that could have been presented at that time. With all of the time that's elapsed since and the response to the action, in particular an appeal, it seems late in the game to be challenging it on the basis that it wasn't titled properly as a final notice. And
I guarantee you the court.
okay, this is my take on it, and I think that at a minimum, it's proper to proceed and consider all that the parties are prepared to present. And in the end, it may come out in your favor anyway. From my perspective, it should be considered on the merits from what the parties have to present. And everything that you're arguing right now can also still be reiterated at the end and perhaps might ultimately persuade the board at that point. But again, that's my recommendation. You all might disagree with that. It's your decision, not mine.
Well, I guess the decision is whether we proceed or not, based on the information provided by Mr. Herman and Ms. Carpenter. I personally feel like we ought to proceed.
I have a serious problem with proceeding with an appeal to a decision that's not been finalized. I don't find that to be logical.
But the UDO said that it can be the first notice. It clearly says final or first
It says
notice.
the first notice can be the final notice, am I correct?
UDO section 2.15C, subsection 2, the final written notice and the initial written notice may be the final notice. Shall state what action the administrator intends to take.
If I may add, not including the entire provision in the UDO. That same section, number 2, says the final written notice shall state what action the administrator intends to take if it's not corrected, and shall advise that the administrator's decision or order may be appealed to the Board of Adjustment. That is not contained in the notice. And you heard from staff that they do typically issue a final notice. And if we'd like to proceed with this, I would call Ms. Meehan to come up, because I have an email from her where she's suggesting that a final notice actually is issued to my clients, and it never happened. So if your inclination is to proceed, then I would like to call her up and ask her about that now.
If there is a final notice issue, are you in the same position as we are right now?
Well, no, not necessarily. I'm asking you to invalidate the notice of violation as a final order. And then the city can do whatever it wants after that point in time. But again, the point of today is challenging those notices of violation. And the first step is that they are insufficient because they don't follow your ordinance under 2.15, giving my clients the notice that's required.
To be sure I'm clear on your point, Ms. Carpenter, if I may restate it to distill down to the a nut of contention. And not to put words in your mouth, but just to be sure I understand it. At this point, at this stage of this hearing, at this point, your argument seems to be that the notice of violation as it exists, as we're seeing it labeled courtesy, first notice, et cetera, is insufficient in and of itself. Is that accurate?
Yes, that's accurate. I would also refer you to the first paragraph where it says, we think there may be a violation. Doesn't assert that there has been a violation.
And
And again, it doesn't follow what the requirements are under the board or.
Actually, it says code enforcement inspector has reason to believe that your property may be in violation.
and based on,
Reason.
and based on your observations of that letter that you just shared, you believe the appellant would like this notice quashed simply as a notice, and then if the city continues to potentially investigate this, then so be it, as long as they follow their own procedures. Is that a fair characterization here?
Yes, I mean, I would say, I'm not gonna tell the city how to do their job moving forward. But as a practical matter, there is very little point in sitting here for 2 hours, putting witnesses on and boatloads of evidence and wasting everyone's time when whatever decision happens today is going to be appealed. I promise you, my clients are going to appeal it. And the first thing the Court of Appeals is going to do is look at those notices and see if they're sufficient under your ordinance. I'm telling you, I don't think they are.
I just assumed you didn't threaten this board, okay? I just assumed you didn't threaten this board. Thank you.
I'm not threatening you, sir. I'm just telling you that my clients are going to appeal.
I hope, stop, John, John, Mr. Allen.
That my clients are going to appeal an adverse decision. And I'm sure the city probably is as well.
I'm sorry, I didn't mean to interrupt you. Were you you're done?
Yes, sir.
If the board found that this notice of violation needed to be withdrawn for insufficiency, would your clients have a problem with that?
No, absolutely not. I would actually, that's what I'm asking you for a motion to do right now, is dismiss both notices of violation as not being final determinations by the staff. Ultimately, what I think I would prefer, and maybe Brady can agree or not agree with this, but we're trying to figure out a way to move through this without litigation. And so I'm kind of hoping that that's the path forward. Can't predict that.
Well, I have a question. Can I ask a question at this point, Brady? What are the, Ms. Carpenter, what are the, your clients? I guess I'm confused. Your clients, your claim is that the clients have don't park on the site. Is that correct? That it's not used as a commercial parking lot. Is that correct?
Well, not testifying, but my issue, one of many issues, is with the way in which the staff has defined the commercial parking lot. And no, their property has not been used for a commercial parking lot under our interpretation of what that means.
Then why are they concerned about this notice of violation? How are they being harmed?
Today. Because the city is citing them for violating an ordinance and imposing fines.
Are people parking on the lot? Or do the appellants stipulate that they're not parking on the lot, or that it's just not commercial activity?
I will stipulate that we are not in violation of the commercial parking lot ordinance.
Okay. I hear that, and it's just even more seems like we're walking around an elephant in the room, and the gist appears to be parking is happening and the city doesn't particularly object to that. We just need to get the paperwork done. Is that fair in the appellant's eyes?
Well, based on the staff presentation, I think it's pretty obvious that parking was being allowed by the city on all 4 of those residentially zoned lots for years.
We can't,
But that to quote unquote, make it legally acceptable, I think that is the elephant in the room. And again, I'd like to have that be something that we address absent litigation, but today we're here about notices of violation, not fixing that problem.
is it fair to say that a hearing like this is not a workshop in which those types of points of agreement can be worked out? And perhaps if this notice were withdrawn, the appellant and the city could meet and reach a meeting of the minds?
I'm very hopeful that we could do that. Obviously, I can't promise anything, but again, in order to move forward, we have to address the notices of violation that are outstanding at this time.
Mr. Herman, do you have anything to add to that?
I actually agree with Ms. Carpenter. I mean, we've already hashed this out for probably 25 minutes and starting to get into testimony of where you're having the lawyers go and sort of argue their case, which is a very slippery slope. But I do agree with Ms. Carpenter to the extent that it would be somewhat wasteful of, I agree, at least over an hour of testimony only to come to the same conclusion that you think the notice of violations are insufficient. So, I mean, she's asked for you all to make a ruling on that. It probably makes sense at this point. The only thing I'll go and add is, I mean, the UDO has the notice of violation provision, which is consistent with almost every municipality's ordinance. With the exception of that right in giving notice of an appeal, the statutes do not mandate that. They say you do have a right. It doesn't say that your municipal ordinance has to go and state as such. And I'm not saying that the letter did not contain that clause. It should have and it didn't. But for all the reasons I just went and said, if that was truly a procedural defect, it could have been noted at the onset and corrected. And we wait all the way to this time for it to go and be brought up. I'll also go into that. I mean, this notice of violation letter, I mean, it states everything that is otherwise required. It states what the violation is. It's for commercial parking, which is unpermitted use in the R10 zoning district. It says the amount of time you need to go in order to comply, possible penalties in terms of if you don't go and comply. And then it says to correct the violation, seize the use of commercial parking. I mean, I think all of those are the things that are set forth verbatim in that UDO section 2.15 subsection C. I'll leave it at that, but I do think at this point we should go ahead and make a decision one way or the other.
Yeah, I would agree with that. And again, I'm not advocating for a result. I'm trying to give you advice that's on point with respect to what you should do, given this issue presented to you. And the only thing else I would observe about the UDO language on this issue of whether the notice was a notice of a final nature should be considered as such as it does have language in there that the person providing the notice of violation, which is presumably the code enforcement officer, shall certify to the city clerk that the notice was provided, and that certificate shall be deemed conclusive in the absence of fraud. So it's essentially meaning that if a certification is made that the notice was provided, then that notice of violation is deemed conclusive in the sense of having a finality to it. Of course, that doesn't mean that there aren't appellate rights and the ability to challenge the finding that's been made by the code enforcement officer. But in terms of the content of the effect of a notice of violation and how it may be titled and how it's framed, it seems as though the elements are there. It is missing the technical element of right to appeal. Although that is there, the intent behind that, obviously, I think you should consider the spirit of that. And the purpose of it is to ensure that those who get notices are aware of their rights. And here they were clearly aware of that right. They exercised it. Had they not done so, that language is there for all intents and purposes. If they didn't appeal in time, they could come back and say, well, we're entitled to file a late appeal because there was no indication in the letter that we had a right to an appeal within a certain period of time. That's where that becomes germane, I think, principally speaking, but it is a technical defect. And it's something that's relevant to your decision about what to do at this point. And that is up to you, but I do think you need to make a decision about it. terms of whether to proceed.
Mr. Herman?
I just have really one quick thing, and then I'll leave it to Ms. Carpenter if she wants to add anything else. In looking at that paragraph that, that Ray was reading, it was the subsection above the one that I've been referring to. But at the very last sentence, it says additional written notices may be sent at the UDO administrator's discretion. So that again goes to that the one notice of violation can be the final notice of violation, regardless of what the title of the letter says.
I think the question before us is whether we feel comfortable to move forward. I mean, do we have, anybody have any questions, first of all? I think that's where we're at.
Mr.
And
Chairman,
yes, sir.
I continue to be troubled that we're in the middle of what should be a process of resolving this without coming to hearings and things like that, but that's beside the point. I would like to make a motion that we void the two citations, notices that are under appeal, and with the stipulation that this is in no way to imply anything about the substance of the matter, just that they need better procedural compliance with the UDO requirements for these types of notices.
So
Void
You're reversing the decision?
we void the notices, which nullifies I don't think there is a decision by the administrator because it's not final. Say
because of the defect.
because of the defect.
Technical.
And so we're not
Omissions.
we're not rendering a decision on the administrator's decision. We're just saying these notices, are void.
You choose not to do that, right? How does that impact their case?
Yes, legally, what would happen moving forward then?
Well, it's an interesting question. I mean, normally you go through those 5 steps in order to make your determination in terms of how you're going to treat I guess it's just for this one. It's just affirm, reverse, or modify. If you think about it, it seems as though there was what's really happening though at the forefront is we're here on an appeal that was brought by the applicants in response to a finding which they treated as something they needed to.
They accepted that finding.
So we have a pending appeal of what is being otherwise treated as an adverse administrative action. So I don't know how you don't rule on the merits of the administrative action to undo everything. There's an appeal from what otherwise is an enforceable action because of the nature that it came to this board. It wouldn't be here but for that situation. So I think you do have to, I think you would essentially have to reverse whatever findings were made with respect to this letter.
If there's no finding, then how can we reverse it?
Well,
because we would essentially be saying that the finding does not, that the finding, so, the parking doesn't exist. And I don't think we can do that based on the evidence in front of us.
If there's a determination that the UDO essentially hasn't been complied with, the code enforcement officer or the city or both did not comply with the steps, your perspective, necessary to perfect violation, then you are finding that what happened below is not a valid process, not a valid finding to the extent that there is one. I just don't know that you could simply vacate the whole proceedings on your own.
Then can we continue this proceeding for additional resolution by the parties?
Clarify what I'm actually asking for. Simplify it. If the motion that's been made to void or vacate the NOVs is passed, then the appeal becomes moot.
If you would,
We need to make it. Specific.
if in fact you can just void them, yes, it's just, a little bit procedurally
Can the
complex.
city withdraw the notices based on insufficiency?
But I think that's why I'm more inclined to think that the step would be to determine that that the finding is not, of the code enforcement officer, is essentially not effective. I suppose, though, if you want to characterize it as there was no finding at all, or no sufficiently final finding, then you could deem it as such and say that you are essentially, I guess, just vacating the underlying notices as not being operative or not having an effect. If they're deemed ineffective, presumably if this board is standing in the shoes of the code enforcement officer, which it can and does in these contexts, it should be able to essentially vacate a prior action as ineffective or otherwise not having any operation. I think that's what you'd have to do, is essentially treat it as though.
Okay, so how could that be expressed in a motion?
I think you would move to essentially render ineffective and therefore vacate the action, or render inoperative. So render ineffective and inoperative the action of the code enforcement officer with respect to these letters, so that the notices of violations just don't have any effect.
Does
And
that,
in which case, if that did happen, then I agree, the appeal that they have brought would be a moot. It would be legally moot. They wouldn't have to do anything. You wouldn't have to do anything on it.
does that prejudice or imply a finding on the facts at issue here?
No, and I think you could stipulate that in your determination that you're not making any determinations on the merits of any future notices that may be issued, assuming the city decides to continue to pursue that type of notice. You're not making any determinations with respect to the merits of the issue.
So if we were to vacate that part of the administrators, letters and stuff like that, does that preclude the city to bringing it back in the future?
No,
I mean, can they
I think that you,
issue their notice again after they do appropriate notifications, or what she would say are appropriate notifications?
I think that you could specify in any such order that you are taking this action to render inoperative and ineffective just specifically these notices that were issued on those dates as they are currently constituted, without prejudice to the city and the enforcement officer taking any future action they may choose to take with respect to the condition of the property as it stands. But I think that you could protect against that. Yeah, it would be just as though the notices were never issued, essentially. If the conditions that are of concern remain in the same condition, then the city would be able to proceed based on those existing facts. But yeah, so again, this is a question to be decided. The board would have to have a majority decision on that. But, Brady, I don't know if you have any other comments about that or not. But
I mean, I have a lot of things going through my mind of how to go and classify this, but I also, at the same time, I don't want to go and bolster and aid opposing counsel's argument as it pertains to this. I'll just go and say an analogy I can go and think of that would be in this type of situation is if an appeal is filed and whether you all think that was a timely appeal, that's something that could be cited from the onset. I think that's a little bit similar to what's happened here, and that's really a subject matter jurisdiction question. I think what opposing counsel is getting at is the notice itself is not a final binding determination to the extent that that can be appealed, or otherwise, one way you could look at it, it's a procedural defect. But what I want to go and avoid though is because if it's leaning towards of you all wanting to void the notice of violations, what I don't want to go and happen is to have a full blown reversal without going to the substance and the evidence of the actual underlying violation. And then it becomes re judicata issues for the city to then go and have a subsequent notice of violation and whether they want to go and appeal to you all again. So I want to state that for the record, that if we're going in that direction, and that's what you all decide, there's procedural defects, then so be it, but that does not preclude the city tomorrow to go and issue a notice of violation. And then we'll just go through the same song and dance here in 90 days. I mean, that's essentially what we're going to go and do anyway, so.
Yeah, and I think that if such an action were taken, then as to the factual or substantive merits of any future notice of violation, I don't think that if you dismiss it on procedural grounds, just simply facially defective notice, that would have any implication on the time period either. The time period that you would cite if you wanted to pursue another violation notice with respect to a claim of violation, because, for example, these notices refer to specific dates that were some time ago, right? And the violations are, the allegations of the violations are based on those dates. So you have those dates and other dates in between, and then all the way up through today, now into 2026, you have that entire time period is a period that would be, that your decision to vacate for procedural purposes only doesn't implicate. So I'm just saying, like, for example, since this is an April 8th incident, there's not a reason why a dismissal on or a vacature of this action on procedural grounds would preclude the city from making a future allegation of violation with respect to that same date or some other date. It's just as though the notices were never issued.
And they start over. The city wouldn't be precluded from starting over.
Right.
Mr. Chairman, I withdraw my motion that's on the table at this point, but I think Mr. Muska wants to make one.
Mr. Chairman, I've got a proposal for the board to consider as a motion. I'm not saying it's verbatim, but it's just jotting down some ideas. Move to reject the administrative development decision due to insufficiency of the foundational NOV. Said motion does not preclude the city's ability to pursue this matter at some future date.
That sounds a little bit like you're rejecting the action itself and maybe a little bit too close to the merit side of it. I think it's better framed in terms of the board is moving to render ineffective and inoperative the notices of violations dated whatever the two dates are on the basis that they are procedurally defective or deficient without prejudice to the city's ability to, or the code enforcement officer's ability to revisit, reconsider, and perhaps impose a violation based upon future findings and a future notice.
Why are we kicking the can down the road?
Say what, Rodney?
Why aren't we, why are we gonna prolong this? If they can
Well, that's.
We haven't voted to do
We
that
haven't-
yet.
Right.
That's what he's asking why.
Yeah,
No, should do it. He said,
you're-
why should we vote?
You're hitting on a good point about the practical side of it, right? Because it is as Mr. Herman characterized it, kind of a song and dance, because the city can just go back and issue a final notice that has all of the required elements, and then here we are again. Yeah, so that's the practical side of it. The question is whether the practical hassle or complications of pursuing it in that way is outweigh concerns about the potential procedural defects of the notices themselves and what trouble that may create, right? That's a decision for you all to make, and it's really weighing out those variables.
We can't decide if the merits of the underlying facts of the citation and the finding that the code administrator implemented without deciding whether the first point of contention, which is whether the thing was done properly and legally. And my point is, if it wasn't, it does not, I think it's obvious, it doesn't look to me like it was done properly and legally. We need to get that dealt with and put away. And then if the issue comes up again, we can decide the issue on its own merits rather than getting
Well-
bogged down in procedural tit for tat.
As an option to that, what if, do we have the ability to table it for whatever, 30 days? And in the meantime, the city can issue another notice that clearly says final and offers all possible options on how to resolve the problem.
I don't think you could do that properly. And, you know, I think that you need to be careful too, not to suggest on the basis of your decision that, that because of the way the UDO itself is written, that there needs to be a hyper-technical version of this letter to be effective. In other words, one that is captioned and framed and stated as final when the UDO says that the initial notice is sufficient by itself to be final. So you have to be careful how you characterize the situation and not suggest that next time around the letter has to now be hyper-technical and meet requirements that are above the standard of the UDO. What we're looking for is basic compliance and sufficient compliance, not perfection. Nor are we trying to raise the standard beyond what the UDO actually requires.
I think what it boils down to, in my mind now, I won't put words in other people's mouths, but if we feel like that proper procedure was not totally followed in the notifications to the appellate, if there's, and I sense that there is some uncomfortableness with that they weren't, I guess, as precise as they could be. Basically, we need to rule on that right now. If that's I think that's where we're at in a point where we need to decide whether we go forward or do we, stop right now.
What is the owner's future idea for those lots?
That's not really an issue today.
Right. So, I mean, I think, Tuck was onto something, I thought, with pairing some of the things that Ray said. But, we can bring it to a vote to proceed with the meeting and go through. I can't make a motion, so someone has to make a motion.
And sorry to go interrupt, but it's obvious that the right to an appeal, I can see that deficiency, but if you guys are leaning towards with a motion on what needs to go and be corrected, I ask that you be specific. So when we go and do this again, we know exactly what to go and correct. And to Ray's point, I mean, the UDO says that it can be, the first notice can be the final notice. So, I mean, is it just deleting one word? Does that make it legally sufficient? Again, I want it to be correct for you all if we're going to go down that route. But again, I'm stating our position that I think it is, the notice of violations are sufficient. We should continue.
Brady, I agree with you. I can only speak for myself. To me, I thought Ms. Carpenter made a pretty good argument about certain holes that are in the NOV, and my personal preference would be to get that thing locked down. If there were, let's just say there were 4 items that if they were worded different, that would no longer be an opportunity to appeal or not appeal, but the NOV itself, the language in it would be defensible, no matter how far you went up with it. then we get into the meat of the issue. But I would like to have an NOV where it was worded in such a way that it didn't become an issue. And then we get into the case that's before us. That's just get rid of all the ambiguity, subjectivity, holes, deficiencies, whatever you want to call them. Get that away from us so then we can consider the matter at hand.
The merits.
Yeah,
of the-
that's
Of the appeal, right,
just
right.
put us in a defensible
We're arguing
position.
on technicalities of the paperwork and we're not
Right.
dealing with the actual issue.
Mr. Chairman, I think I'm ready to make a motion based on our recent discussions.
And Jason, I would just say to number 2, include as part of the motion, the specific stipulation that there is no determination being made on the merits of anything about anything substantive about what was in the notice. It's entirely a procedural issue. And therefore, any vacature or finding of inoperability of those notices does not prejudice the city, the code enforcement officer from pursuing another notice of violation on the same or related bases.
Yeah.
All right. I move that,
Hold on, Scott, can you hear?
So long as I can get the motion clearly stated, the motion clearly stated, I can get it here. And so it's completely clear. Do you understand? It's essential.
Yeah,
for
we'll
me.
get it.
All right, I just
It'll
wanted
be
to say
right
that.
before you write it.
Thank you very much.
I move that we render inoperative the notices of violation, 2 notices of violation issued April 9th, 2025. One of them regarding case number 20254010, applicable to property parcel ID 237LF001. The other applying to, related to case number 20254011, applicable to property 237LF002. And that by rendering those notices inoperable, this board in no way makes a finding related to the actual matters and raised in the notices. This is limited entirely to the procedural deficiencies we find in the notices, in specifically that they do not meet the requirements for such notices in the UDO. Anything to change?
No, I think that's sufficient.
Scott, did that reach?
Scott,
I'll second it.
is that?
Oh, I'm sorry. Second.
Yeah.
Seconded.
Been seconded, question. Does that cover, Ray, what you feel like we need to cover?
I think so.
Just as a matter of wordsmithing for the attorneys, are y'all okay with the term inoperable?
I think inoperable or ineffective is fine as long as that's associated with the procedural deficiencies that have been found and not any sort of substantive findings, which is what the motion states.
Everybody good? Motion's been seconded, right? Okay. All in favor signify by saying aye. Opposed, same sign.
And as a technical matter, with that finding, I mean, it just sort of it happens by nature, but the nature of that finding is that it renders the pending appeal moot. So that just would put a pin in the whole thing. You are here technically to decide an appeal, but now you don't have to decide the appeal. So I think I don't know that you need a motion to that effect, but just a recognition that the inoperability of those notices of violation has the effect of rendering the appeal moot such that the board does not need to act on that appeal. Well, I think that you could put it on the record. Maybe perhaps that's just the way to do it. The only real way to get a clear statement on the record is for somebody to make a motion recognizing that the board need not act, will not act on the pending appeal because it's been rendered moot.
I'll make a motion that the board does not need to take further action on this appeal item because of the previous motion, and it would be moot point to do so.
5 seconds.
Second.
All in favor, signify by saying aye. Opposed, same sign. We're closed for this. What's our, I mean, we're done for, on this case.
Right. I mean, I think that's right. I mean, we're going to have minutes that already memorialize what happened and why. I think that if there's an order, the order will be limited to the finding they just made that it was moot. Because what was before the board was the appeal. Now it's no longer there. And the action you were asked to take was to act on the appeal. Your action was to deem it moot. Yeah, I would say so. Yes. Yeah, there's, that starts back at the city level, right? And works its way up, the issuance of a violation notice and framing it in a manner that takes into account what we've discussed today. And then from there, if they appeal it, then we're right back here. So then we're into the substance of it, which we haven't gotten to yet.
But I do want to personally say it looks like this is a matter that might be resolvable, and certainly hope to see that.
Well, I close this hearing. Any other questions, comments? Yeah. All right, this hearing's closed. Thank you.
Did you not have something else on the calendar?
Yeah, no, we're not adjourned. We got a couple things real quick, y'all. Real quick.
Other business.
Included in your packet was the meeting schedule for next year. I met with Scott. I do know that Thanksgiving and Christmas, we've already addressed that, so we'll be moving down, but we have to adopt a meeting schedule for the future. Pardon?
Can we go ahead and do those new dates?
Can we do the new gates here, Scott? For the November and December? New meeting dates? If we feel like these are too close to Christmas and Thanksgiving, or
It really is, it's up to you. I mean, it doesn't matter. I can do it when time comes. It's just my procedure. It's not a big deal.
It's
for
hard to
us,
get them
for planning,
rescheduled.
it'd be nice
Yeah.
to do it. So I'm open to whatever y'all want.
Do we want to just roll them back to the next Tuesday? Just push them ahead a week? I don't know. I don't have a calendar in front of me, so I don't know exactly what that does, but I
If
assume
you,
Thanksgiving, that would be fine, wouldn't it?
if you want, might be the best thing to do to make sure that I get it is just email me what you want to do. You can approve it with the changes that we make going forward. And at least I'll have it so it's, approved and adopted. And then we can, before I actually post it, we can put the dates you want on there. Does that sound sufficient for the board?
Fine with me. Yeah.
Okay, so yeah, if you want, just email me the changes and when the agenda does, go out, it'll be for the days that you want.
just want to get the dates locked in the next
So people
month or
can
two.
plan.
So we can plan and
Right.
so applicants who come in say September, know they're not going to get heard in November.
So just so you understand, I'm going to post this in the next week. So as long as you give me the dates that you want
You
to
want to pick
change
them right now, guys?
for the holidays. Yeah. This is just to make sure that the open meetings law is in compliance with our office.
Hey Pete, this accurate?
Scott, you've
Jason
missed some
expired
of
in
the
2025.
fun we've had trying to
I don't know.
reschedule these things in the winter time. And so,
All right.
but you're here for it now.
Y'all come up with, I won't be here.
Uh,
Y'all
Is it-
pick it. I don't want.
We can,
Come on,
to
man.
to me, the easiest thing to do is either move it back a week or up a week, each
Right.
one of them. I don't, and I don't really care which.
We
I
need,
guess the problem with moving them up or back a week means we have less time to get things done and
We're gonna talk
whatever.
about that
So
real quick next too.
might be preferable just to move them to the next week.
So like I said, if you guys want to have a discussion about this when we're not live during a meeting,
Okay.
and you can send it to me in an email, just send it to the chair will send it to me. I won't publish the meetings until I have the dates from you. We just need to make sure that the board
We
approves
got
me.
a motion on the floor, Rodney? To do what?
29th. Hang on, let's see. So November's would go to December 1st.
And December's would
Yeah,
be.
so we'd change Thanksgivings from the 24th to December 1st, which is a Tuesday, and change the December meeting from the 22nd to the 29th. So December 29th and December
You
1st.
want to stay away from 29th. That's
Stay away from the
travel week.
29th.
I mean, that's a travel week for a lot of people between Christmas and. I'm just thinking, that,
So you want to do it the 22nd?
I'm not gonna
Well,
be
that's the
here,
week
so
of
y'all-
Christmas. I mean,
Like I said,
it's hard to
gentlemen,
avoid.
gentlemen,
It's-
gentlemen, like I said, if you wouldn't mind just sending me your preferred dates in an email, we can hash it out in email. It doesn't have to be hashed out here.
okay.
okay.
Okay? Thank you.
All right, several of you have mentioned to me in the past that we need to package out much earlier, or not much earlier, but some, more lead time. And I've talked to Scott and Mo about this, and I think tonight is a perfect example. Boy, there's so much complexity to the things that we're starting to deal with that we need time as a board to drill down, have time to drill down on some of the applications and that come in. So what's your thoughts, Mo, Scott? I mean, I know it's a burden on y'all, so.
No, as long as we know the schedule and what we need to, when you would like to have them previously, we can definitely schedule for that. I would say that as we had been working, it was always, the latest would be the Friday prior to the meeting if there weren't more than just a few items on the agenda. I'm happy to have it earlier. I mean, we just need to know what you would like and we can make that happen. Like, do you want it a week before? I mean, we had this one out Thursday. Was that enough time? Would you prefer the Tuesday before, a
I
whole
think
week?
A week would be
A
give us
week would be
sufficient time.
best. If it's just one simple, quick thing, but then that'll be easy to get out anyway.
Yeah, that's fine. Absolutely. We can work on that. Not a
Thank you,
problem.
Mo.
We'll make that happen rather. How about that?
Thank you.
Thank you.
Anything else,
Brady.
Scott?
Still would like to
Brady.
have a motion in a second on the adoption of the agenda. I would still like to make a motion if
I
you
make a
could.
motion to adopt the agenda.
Yeah, we can do the adjustments
second.
later.
Brady.
Got a second? All in favor, say aye. Opposed, same sign. I got a motion to adjourn. All in favor, say aye. All right. Thank you.